In today's episode, we're heading back to the Harris County Criminal Court in Houston, Texas, to once again review some probable cause hearings decided by Judge David Fleischer. In each of these cases, Judge Fleischer decided that there was not enough evidence to support the criminal charges brought against the defendants. This episode is part of an ongoing series dedicated to helping our viewers better understand how probable cause plays out in an actual courtroom, especially when decided by a reasonable and impartial judge. Let us know if there are any probable cause cases you'd like to see included in this series in the comments down below. And with that said, let's get started with our first hearing. On February 21st, 2025, Edward Love Jr. and Edward Love III were charged with evading arrest or detention based on allegations that they ran away when approached by a police officer. A probable cause hearing was held on February 28th in Judge Fleischer's courtroom.
You ready? Good morning. Happy Friday. Michael Love, come up.
It's two, Michael Love and Michael Love Jr.
Oh, really?
Junior and third.
Okay, Michael Love Jr. and Senior, come on up. Who's Junior? And you are? The third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, officer dispatched First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incidents indicating this was possible burglary progress, with fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to comply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both detained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, Your Honor.
Cops never tell them to stop.
Exactly.
And what are they doing wrong? I guess, what is this, Minority Report? You know what I mean?
I don't have anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand? Sir. I'm going to find no probable cause on both of your cases.
Thank you, Your Honor.
Take a seat.
Judge Fleischer determines that there is no probable cause to support the charges against the Loves for evading arrest or detention under Section 3804 of the Texas Penal Code, which makes it an offense to intentionally flee from a peace officer who is lawfully attempting to arrest or detain an individual. The statute requires that the person know that the pursuer is a police officer who is actively attempting to detain them, typically communicated through a clear directive to stop or otherwise submit to authority. Now, because neither Mr. Love Jr. nor Mr. Love III was ordered to stop by the officer, this essential element of intentional flight from a lawful detention was never triggered, and the statute would not apply in the absence of a communicated attempt to detain. Accordingly, the state dismissed the charges on the same day. Before we continue the interaction, I want to give a big thanks to today's sponsor, Free Ash. If you're anything like me, you've probably seen 1,000 make money online claims and tuned them all out. So, when I tried Free Cash, I treated it like an experiment. Does this actually pay? And is it a pain to use? Free Cash is a website where you earn real money for doing simple online tasks like answering surveys, trying out apps, or playing games. For every task you complete, you get coins. And those coins can be cashed out to PayPal, crypto, or gift cards once you hit the threshold. No mystery system, no points you can't use. It's just straight value that you can actually withdraw. What I like is the flexibility. You can scroll through offers and pick what fits you. Games, surveys, or other promos. If you're already the type of person who's on your phone at night anyway, this lets you turn that time into a little extra cash instead of just doom scrolling. And because I'm skeptical by default, I paid attention to the trust side of it. Free Cash is sitting at about 4.8 stars on Trustpilot with thousands of positive reviews behind it. They also make the cash-out process very transparent. You can see your balance, choose how you want to withdraw, and actually watch it leave the site and hit your chosen payout method. That transparency goes a long way for me. If you want to give Free Cash a try, then use my link on screen and in the description below or scan the QR code on screen. Now, this might not set you up for retirement, but if you're going to be on your phone anyway, you might as well get paid for it. Thanks again to Free Cash for sponsoring today's episode. The next probable cause hearing we will cover in this episode took place on April 14th, 2025 after Nicholas Kubler was charged with second offense driving while intoxicated on April 11th.
So I had a guy charged with a felony that was arraigned this morning, but he's on your docket later in the week, and I was hoping just to get it done so we can.
Of course, let's do it.
Okay,
Do you have the cause number?
I do, 255-9578. He's already got conditions from Judge Simons. Where'd he go?
Judge Simons.
Yeah,
Okay.
Judge D. Simons. And so it's my understanding there's no alcohol. He's got a device also already, I think, or at least we can double check.
All right, sir. You are Mr. Kubler.
Kubler, yes, sir.
Kubler. Mr. Kubler, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I see. So he's also charged with abandonment. Is it out of the same transaction?
Yeah, we had a long discussion with him this morning.
I don't know anything about it. Let's find out what's going on, please.
On April 11th, 2025, an officer was dispatched to an unknown incident or accident, excuse me, and noticed a vehicle, a pickup truck, illegally parked in the front yard of the residence. There were fresh tires, skid marks, a broken wheel, and axle visibly appeared to be damaged from the Ram truck to a legally parked red Jeep Compass. The law enforcement officer made contact with pulling it, and then it said the damage to the Jeep was probably $5,000. The defendant admitted to driving the truck. Was later identified. The officer also made contact with the wheel witness, who said that he witnessed the defendant in the white truck in the driver's seat behind the wheel and observed an exit vehicle from the driver's side door. Upon exiting the vehicle, the wheel witness observed he was not stumbling, and then the wheel witness observed slurred speech and strong odor of alcohol beverage emitting from the defendant's breath and person. The defendant also admitted that he was trying to flee the scene and go home, but his vehicle was stolen. The officer made contact with the defendant, who was detained, and noticed a strong odor of alcoholic beverage. The officer then conducted a standardized field sobriety test, where he witnessed, sorry, Your Honor, the DIMS leaves off and does not show the standardized field sobriety test results. The officer asked the defendant his intoxication level. The defendant said he was at a 6 out of 10. The defendant said he does not believe it was safe to operate his motor vehicle at this level of intoxication, but had an 11-year-old passenger.
He did not.
I'm sorry, he did not. He did not. I apologize. We can just have just a moment to see if I can.
Judge, I'm going to tell you that's kind of where the DWI investigation stops. The first response that I have is that no field sobriety tests were performed. It also, the credibility of the wheel witness was never discussed in the DIMS, whether the officer found them credible or reliable, etc. So I really can't make a lot of sense out of.
It's like the DIMS you're reading these like going through a drive-through, man. I mean, really, who's writing the reports?
Yes, Your Honor.
Over and over and over. I mean, really,
Trying to see if I can find anything else.
case after case, we're just,
So, Judge,
DIMS don't say it. They'll say is the results of those very revealed sobriety tests, and we do not have an officer.
How on earth am I supposed to find probable cause when Mickey Mouse is writing these reports?
I don't say. I don't know why it's not in the DIMS. Obviously, we didn't write it in here. We represent what is written in there, and so I understand your frustration. I'm highly frustrated.
Mr. Kubler, I'm going to find no probable cause in your case. Don't kill anyone. You know, every single day on the news, how many people die in our county because of a DWI? How many? Every single day. We lead the nation in alcohol-related collisions and fatalities because of boneheaded moves that are made day in, day out. Now, this is not to say that they may not indict this case at a later time, but whatever, just don't kill someone, please. Take a seat, please, sir.
Thank you, Judge.
Thanks.
Judge Fleer enters a finding of no probable cause based on deficiencies of allegations in the so-called DIMS report. A DIMS, short for the District Attorney Intake Management System, is the report that's generated when a police officer electronically submits criminal charges for a warrantless arrest to the Harris County District Attorney's Office. According to the DIMS manual, the report includes a summary of facts that provides the details of the offense, which is then relied upon by the District Attorney's Office to show probable cause. Here, Judge Fleer concluded that the DIMS report from the arresting officer did not include enough evidence to provide probable cause to support the charge. However, on May 23, 2025, a new complaint stemming from the same arrest was filed, charging Mr. Blur with felony third-time driving while intoxicated after a second prior DWI conviction was identified. On May 27, the original charge of second offense DWI was dismissed, while as of the date of writing this episode, the felony charge remains pending. Our next probable cause hearing occurred on April 4, 2025, after Jonathan Cerna was charged on March 29 with interference with public duties. Officers executing an arrest warrant for a felony murder suspect outside Mr. Sin's home alleged that he refused their command to remain outside while they secured the area, resulting in his arrest and the criminal charge.
All right, Judge, next is page 21, Cerna, Jonathan.
Good morning, Mr. Cerna. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir. On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle and began walking to the residence where the murder suspect was. The officer supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there. Stop. Oh, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant.
Okay.
He stopped. He refused to stop going towards the residence. Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence. And that's been this incident.
Read it again. Do you see the line?
Yes, Your Honor. On March 28, 2025, the law enforcement officer in Squad 5 of the Houston Police Department's Gang Division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant once again ignored the officers. The law enforcement officer grabbed the defendant and made him off balance and ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what, so I was originally reading the summary. I'm going straight from the DIMS now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I don't think
I'm gonna find no probable cause in your case. Just be careful, man. When you get into a pissing match with
I understand.
who's gonna win?
They are. I understand.
No.
Yes, sir.
Hands,
All right. Sit down.
please.
Judge Fleer determines that there is no probable cause to support the charge of interference with public duties. Under Section 38(15) of the Texas Penal Code, an individual commits the offense of interference with public duties by interrupting, disrupting, impeding, or interfering with a peace officer performing a lawful duty. While failing to comply with a law enforcement officer's instruction pertaining to physical conduct can constitute a violation of this statute under some circumstances, the command must be lawful and the refusal to comply with the command must actually interfere with the police officer's performance of their duties. Here, the officers were focused on a suspect outside the residence and Mr. Cerna, who was not the target of the warrant, did not threaten, obstruct, or physically interfere with their movements. Although the officers instructed him to stay outside, the evidence did not suggest that his attempt to enter his own home created a safety risk or meaningfully disrupted the arrest operation. Without evidence that his behavior actually impeded the officer's duties, Judge Flee concluded that his conduct did not satisfy the statutory requirements for interference. Therefore, the state dismissed the charge against him the same day that Judge Fleischer found no probable cause. Our final hearing of this episode took place on April 25, 2025, after Joseph Ramirez was charged with DWI on April 18th.
The council's approaching for page 15.
Okay.
Ramirez, Joseph.
Hi, Frank. How are you? You ready? Come on. All right. Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained, and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knees. He can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol. Anything, there's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's the odor of alcohol.
Come on, man.
I'm just saying. I mean, that the officer actually asked him that question.
What are they, the little alcohol that you put on your skin? You're telling me that?
I don't know how it works, Judge. I've never had a tattoo.
You're killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah.
That's
That it?
all we have before he initiated the standardized post-mortem test.
Okay, that's not enough. All right, I'm going to find no probable cause in your case, Mr. Ramirez. You know, We have enough death on our streets now. You know, $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank.
Judge Fleer concluded that there was no probable cause for the DWI charge because the only evidence that the officer had before conducting field sobriety testing was the alleged smell of alcohol on Mr. Ramirez's breath. Unlike a number of other states, Texas law requires police officers to have reasonable suspicion that a driver has committed an intoxication offense in order to request field sobriety testing. Because the DWI statute only prohibits driving while intoxicated, not driving after consuming any amount of alcohol, Judge Fleer determined that the odor of alcohol alone was not enough to provide the officer with reasonable suspicion to require field sobriety testing, as there was no evidence that demonstrated that Mr. Ramirez was actually intoxicated. Case law and Article 38. 23 of the Texas Code Criminal Procedure requires evidence that a police officer obtains through a constitutional violation, such as requiring field sobriety testing without reasonable suspicion to be suppressed. Accordingly, because the results of the field sobriety testing and subsequent blood draw could not be considered, Judge Fleer decided that there was no probable cause for the arrest, and the state dismissed the DWI charge the same day. At the end of the day, these hearings illustrate how essential it is for courts to act as a constitutional checkpoint in the criminal process. In each case that we reviewed, Judge Fleer adhered to the basic principle that probable cause cannot rest on assumptions, incomplete narratives, or statutory elements that the state simply failed to establish. Whether officers neglected to communicate a lawful order, omitted critical facts from a DIMS report, misapplied statutes, or relied on evidence obtained through an unlawful extension of a traffic stop, the result was the same. The Constitution required more evidence than what the state presented. These rulings reinforce that probable cause is not a mere formality, but a meaningful safeguard against unjustified arrests, and that every charge, no matter how minor or routine, must be supported by competent evidence that satisfies the law. Judge Fleer's decisions in these cases remind us that the rights of the accused do not yield to convenience, and that judicial oversight remains one of the most important protections built into our legal system. Let us know if there is a case or courtroom interaction that you'd like us to explore in the comments down below. Thank you for watching, and don't forget to like and subscribe so that we can help foster a more informed society. And thanks again to Free Ash for sponsoring this episode.